peut lever. Please be seated. Veuillez vous asseoir.
Thank you very much and welcome back, everyone. Um, we will now proceed with uh, um, the next cluster of questions. Um, I understand that the legal team for Jordan would have liked to ask if, make a few more observations than in the last segment. We will try and capture some of that as we go along. Thank you very much. So we will proceed with the next cluster of questions, and my colleague Judge Hofmansky would put those questions on the record. Judge Hofmansky, please.
Thank you very much, Mr. President. Excuse me for taking your time, but it's really necessary to read all the questions to record. Now we start the cluster B, Security Council referrals under Article 13B of the Statute and Resolution 1593. Question A. For the purpose of Chapter 7 of the United Nations Charter, does the Security Council have the power to waive, displace or override the immunity of head of state under customary international law or conventional international law? If so, must this be done expressly or can it be a necessary implication? Question B. For the purposes of Chapter 7 of the UN Charter, does the Security Council have the power to make conventional provisions of the statute applicable to states that are not party to it? If so, must this be done expressly or can it be by necessary implication? Question C. In this respect, what is the intendment of Article 13b of the statute when it provides that the court must exercise its jurisdiction in accordance with the provisions of the statute? Question D. Does Article 13b of the statute entail the application of the statute to a non-state party on the same basis as a state party, or does it only serve to instrumentalize the court to the Chapter 7 powers of the Security Council? Question E. What is the significance, if any, of the fact that the Security Council refers of situation to the court under Article 13b of the statute can only be accomplished by the Security Council under Chapter 7, not under any other chapter of the United Nations Charter, nor by the United Nations General Assembly? F. Is a proper understanding of the effect of Article 13b of the statute assisted by the hypothesis that the court A is the brainchild of the UN and or B was established as a separate entity rather than a part of the United Nations? Question G. What is the legal significance and effect of the distinction in paragraph 2 of Resolution 1593 between imposing an obligation to the Republic of the Sudan to cooperate fully while only urging all other states to cooperate fully? Does the former obligation have the same effect on states non-party to the statutes, whether UN member states or otherwise, as it does on the Republic of the Sudan from the perspective of any immunities cognizable under Article 98 of the statute? H. Does the urge in paragraph 2 of Resolution 1593 on all other states to cooperate fully amount to a license excuse or defense permitting states to derogate from any immunities that the Republic of the Sudan might otherwise enjoy under international law. I, given the express recognition in paragraph 6 of Resolution 1593 of specific exception to the Court's jurisdiction, can the resolution reasonably be constructed as recognizing any other exceptions by implication, notwithstanding the requirements of cooperation placed upon UN member states by virtue of various provisions of the UN Charter, including Articles 2, 25, 27, 24.1, 25, 49, and 103. J. Is it right to say that immunity derives essentially from sovereignty? If so, can a UN member state plead its own sovereign immunity in order to avoid the effects of a Chapter 7 measures, particularly having regard to Article 1, 1.3, and 1.4 of the UN Charter and its preamble? K. Can a rule of customary international law be pleaded by a state as a bar against the implementation of a decision of the Security Council taken under Chapter 7, particularly having regard to Articles 2, 25, 27, 24.1, 25, 48, 49, and 103 of the UN Charter? Question L. Is there a difference between the legal effects in the following scenarios where the Security Council uses Chapter 7 powers to: A. Refer a case to the court. B. Create a new ad hoc tribunal like the International Tribunal for the former Yugoslavia or the International Criminal Tribunal for Rwanda. If the Security Council had created a new ad hoc tribunal for Darfur, modeled on the template of the resolution used in the creation of the ICTY and ICTR, would Mr. al-Bashir have enjoyed immunity before that tribunal? M. Since the adoption of the resolution 1593, to what extent, if any, has the Republic of the Sudan complied with its obligation to cooperate fully other than in the matter of the arrest and surrender of Mr. al-Bashir? How many citizens of the Republic of the Sudan are currently subject to an arrest warrant issued by the court, and to what is the extent of the Republic of the Sudan's cooperation in the arrest and surrender of such persons to the court? Question N. Would the recognition of immunity in respect of Mr. al-Bashir render Resolution 1593 wholly or substantially ineffective? And the last question, question O. In the context of a request for arrest and surrender issued by the court following a Security Council referral, could the state be said to be acting as the court's jurisdictional proxy or otherwise in the execution of such requests? What is the relevance, if any, of Article 59 of the statute in this regard? Thank you.
Thank you very much, Judge Hofmansky. And we have now come to the second cluster. As you might have already discerned, we may have in the last segment got ahead of ourselves by foreshadowing some of these questions. But if you've already spoken to it at that time, you just merely need to refer that you've already spoken to it before. But the cluster now gives everyone a systematic opportunity to speak to those questions in case they hadn't done so before. So we will then begin as before. The idea is that these questions should guide counsel in their submissions so they know some of the questions that are troubling the judges, but again, speak freely as you would. We will now invite counsel for Jordan. Mr. Murphy, I see you standing to go first. Please proceed.
Thank you, Mr. President.
I'm required to say something to you, which I also need to keep in mind myself for purposes of proper transcription of the proceedings and interpretation, for us to speak in moderate tone, not too slowly, but not fast, so that things can be captured properly. As I said, I will take note of that caution myself. So please proceed.
Thank you, Mr. President. I will certainly do my best to follow that intermediate path. Jordan has filed a second ground of appeal before the appeals chamber, which I would like to address. And after I speak, with your permission, Mr. Wood will continue, particularly focusing on some of the questions that fall within this Group B. Our second ground of appeal is that the majority in the pretrial chamber erred in concluding that the necessary effect of Security Council Resolution 1593 was that Sudan has rights and duties analogous to those states parties to the statute. This status that it determined Sudan had of being analogous to a party supposedly came about due to a combined effect of paragraphs 1 and 2 of the resolution, which to us is a rather curious alchemy that is challenging to follow and requires analyzing not just the December 2017 decision, which related to Jordan, but also the July 2017 decision that related to South Africa. In any event, this analogous to a party status for Sudan is a crucial part of the pretrial chamber's legal theory. For the pretrial chamber, as we previously discussed, accepted that President al-Bashir enjoys head of state immunity, and further accepted that such immunity would normally protect him from Jordan's criminal jurisdiction under Article 98 of the Rome Statute, since Sudan is not a party to the statute. Yet, under the force of Article 27 of the statute, the majority below said that Article 98 basically drops away because Sudan is no longer a non-party, but instead has the status of analogous to a party. And once that Article 98 disappears, Jordan is suddenly non-compliant for failing to recognize this connect the dots approach. In response to the prosecution's April 2018 pleading, I'd like to just address a few points, if I may. First, Jordan believes it to be obvious that the pretrial chamber, and with respect this prosecution as well, failed to interpret Security Council resolution in accordance with what would be viewed the proper methodology. As indicated by the International Court of Justice in the Kosovo advisory opinion, and we have included in the Jordan judges folder for the day at page 3, the extract from the Kosovo advisory opinion. If you look at that paragraph 94 on page 3 of your judges folder, there are a few elements that the court points to. They start with the idea that guidance may be found in Articles 31 and 32 of the Vienna Convention, which by its terms applies to treaties, but provides a basic methodological approach that the court says is relevant even when you're interpreting a Security Council resolution. It then goes on to say that Security Council resolutions may also require the court to analyze statements by representatives of the Council made at the time of the adoption of the resolution, other resolutions of the Security Council on the same issue, and the subsequent practice of relevant UN organs and of states affected by the given resolutions. In our view, neither the Chamber nor the prosecution have really confronted this methodology squarely and systematically. If they did, we submit that the ordinary meaning of the resolution would lead to a conclusion that supports our second ground of appeal. We think you have to look at the ordinary meaning. We think when you look at the context and when you look at the statements of the council members at the time of the adoption and the practice of the council thereafter, the interpretation that we advance is the correct one.
I think
In this,
Mr. Word did write a very useful article on this long before this case arose in 1995, I think it was, or 1998. But go on.
yes,
Saying
indeed,
more or less the same thing.
Your Honor, and as the lead counsel for Kosovo in the advisory opinion case, I think he brought his knowledge to good use in that instance as well. In our view, you may want to take a hard look at Judge Brichambeau's minority opinion to a certain extent in the December 2017 decision, but even more so in the July 2017 South Africa decision, because he does employ this methodology where he systematically goes through the elements. We think that's the right methodology, and we encourage this court to approach it in the same way. I would also note that Jordan's position has been supported by the African Union and the Arab League in terms of the proper way of interpreting the resolution and the result from that interpretation. Let me turn to a second point, which is when you look at the resolution itself, and here I would direct you to page 4 of our judge's folder where we have reproduced the resolution. If you look at the resolution itself, to us the ordinary meaning leads to a relatively straightforward interpretation. If you look at operative paragraph 1, you see the council deciding to refer the situation in Darfur since 2002 to the prosecutor. In so doing, the council triggered this court's jurisdiction in accordance with Article 13b of the Rome Statute. In the second paragraph of the resolution, the council decides, and I'll quote it, "The government of Sudan shall cooperate fully with and provide any necessary assistance to the court and the prosecutor pursuant to this resolution." This is binding on the government of Sudan. There's no dispute about that in terms of the way it would operate with Article 25 of the UN Charter. Now, obviously, neither of these provisions, paragraph 1 or paragraph 2, says anything about the denial of immunity from foreign criminal jurisdiction. They further say nothing about immunity at all. Neither provision says anything about Article 27 of the Rome Statute, and certainly nothing about Sudan becoming a party or a quasi-party or analogous to a party to the Rome Statute, or, to use the prosecution's somewhat convoluted tongue twister, UNSC situation referral state. That's a term that also appears nowhere in the resolution or in the Rome Statute, for that matter. Instead, what you see there in paragraph 1 is that the resolution is using language that very much mimics the language of a single article of the Rome Statute, which is Article 13. And we've included that as well at page 6 of your judge's folder, although I'm quite sure you have all of the Rome Statute at your fingertips. Recall that paragraph 1 of the resolution has the council deciding to refer the situation in Darfur to the prosecutor of the International Criminal Court. Meanwhile, Article 13b is providing the court with jurisdiction over a situation in which one or more of the crimes appears to have been committed is referred to the prosecutor by the Security Council. acting under Chapter 7. To us, this symbiotic relationship, if you will, between paragraph 1 of the resolution and Article 13B of the statute is very clear, that that's what the resolution in paragraph 1 is triggering, and it speaks volumes about the ordinary meaning of paragraph 1. In short, all paragraph 1 does is activate the exercise of jurisdiction by the court with respect to the situation in Darfur in relation to the crimes that are referred to in Article 5 of the Rome Statute. It does no more than that. It does no less than that. Had the pretrial chamber focused more closely on the ordinary meaning of the resolution, it would have had to accept that paragraph 1 is referring a situation to the court, not a state. Indeed, a reference to the state of Sudan or even the government of Sudan appears nowhere in paragraph 1. The reference is to the situation in Darfur, and that, of course, is a reference to a geographic area, which is in Sudan, but it's not a reference to the state of Sudan. Indeed, the resolution could not, consistent with the Rome Statute, have referred a state to the prosecutor. That's not what the Rome Statute says. We think this is an important point, and it's not a point that either the prosecution or the pretrial chamber has really grappled with. Article 13B of the statute provides for referral of situations to the prosecutor, not referrals of states. If only a situation can be referred, it's difficult to understand why a non-party state should be treated as if it's a state party or analogous to a state party or whatever other name you want to put on it. The position of that state, that non-party state, vis-a-vis the court and the statute remains unchanged based on this referral, unless the Security Council takes some further action beyond what's happened in this resolution. And paragraph 2, which I'll turn to in a moment, is really not of any assistance here, given that it too does not refer to the state of Sudan. Mr. President, members of the Chamber, what Resolution 1593 accomplished is simply that crimes occurring in Darfur since July 2002 are within the jurisdiction of the court, while Sudan remains a non-party to the Rome Statute. Now, if we go past the language of Resolution 1593 and looked at other elements for this proper interpretation, we would find that the understanding of what this means doesn't change. There's virtually no support for the interpretation placed on this by the prosecution in the statements made by the council members at the time Resolution 1593 was adopted. There's virtually no support in the statements made by council members in the past 13 years. And there's no practice of any kind by the council itself since 2005 that would support the proposition that Resolution 1593 was attempting to strip away immunity from foreign criminal jurisdiction. Time precludes running through that practice. I do refer you to Jordan's appeals brief, particularly at paragraphs 73 to 76, and I would note that some of Mr. Newton's comments at the end of yesterday regarding subsequent state practice are pertinent in this regard. I do want to note that for years now, the prosecution has been making reports to the Security Council claiming that states are failing to comply with their interpretation of the Council's resolution. Despite that, and despite some referrals to the Council has taken no action at all to address these purported violations of its resolution. Both the pretrial chamber and the prosecution press hard on the idea that the entirety of the Rome Statute applies to the situation in Darfur, and then they somehow hypothesize that that speaks to the entirety of the statute applying to Sudan. The origins of this hypothesis, the leap that it makes, and its significance is a bit of a mystery to us, as again, the text of the statute, the text of the resolution says nothing about applying the entirety of the Rome Statute to anything, let alone to Sudan. And how that hypothesis differs from declaring Sudan to be a party to the Rome Statute, which, as we understand it, both the prosecution and the pretrial chamber disclaim, that too is a mystery to us. If this hypothesis were really true, then it would lead to a conclusion that Sudan is being treated essentially as a party to the Rome Statute, which would have been completely unnecessary then to have paragraph 2 of the resolution, since if Sudan was already essentially a party, there'd be no need for paragraph 2 if they're already bound to part 9 of the statute. So
I would like to ask you a question at some point, but perhaps this may be a place for you to start thinking about this if you want to get to it later. You will, of course, tell us what other provisions of the Rome Statute beyond Article 13b would apply in the situation, in the prosecution of anyone in the Darfur situation that is beyond Article 13b. Is there any provision of the Rome Statute that applies? If so, why would that apply and not other provisions? I'm sure you've thought about that. No, because the submission seems to be that 27 doesn't apply, but 98 does. And we're saying, okay, I'm not sure if that I rephrase my understanding of your submission correctly. But the point being, we would like to know what provisions of the Rome Statute apply. Thank you.
Thank you, Mr. President. I'm happy to answer that question. It depends what you're saying it applies to. Our submission is that the Rome Statute in its entirety or several provisions or whatever don't apply directly to Sudan. Our submission would be there's been a referral of a situation to the court, and then the court's statute does operate with respect to that situation. So I suppose you could say the statute applies to the situation, fair enough, but it's a leap to say that the statute therefore applies to the state of Sudan. And that's where we're pausing, because the claim is that we now have a UNSC referral situation state, or situation referral state, that has placed Sudan essentially in a party-like status. And we don't see that. So our submission would be Article 13b has triggered your jurisdiction with respect to a situation. You proceed under the statute as you would whenever you have jurisdiction over a situation, but it doesn't change the status of Sudan.
But beneath the application of the statute to Sudan is the essential question of application of the statute in the case concerning President Bashir. Isn't it the case?
Well, I would submit that the court's jurisdiction to investigate a situation and then possibly to indict individuals for crimes committed within that situation is all relevant and is all applicable here. But I would submit that does not somehow transform a non-party state into being something like a party or a quasi-party or however you would put it. It's still a non-party to the statute. And it related to your question is that if you were to say that somehow Sudan is analogous to a party, you then immediately run into the problem that, of course, it doesn't have all the obligations of a party. It wouldn't be expected to show up at the Assembly of States Parties to pay dues. It couldn't trigger the dispute resolution procedures, all that. Even the prosecution, I think, would accept that. I'm sorry, I think I may be speaking too quickly. You excite me with your questions, Mr. President. It's clear that Sudan doesn't have all these obligations, so it leads you into a further problem of, well, which parts of the statute apply to this status of Sudan and which do not. And we think that that, too, is speculative, unclear, and unrealistic. I think instead we're talking about a situation where they remain a non-party. The court continues to operate as it does. It just now has jurisdiction over a situation.
But the thing that brought us here is whether President Bashir enjoys immunity. So beneath or beyond, or in addition to the question whether the statute applies to Sudan, it's that other question, that core of it. Can President Bashir enjoy immunity when the Security Council has referred the case to the ICC to be tried pursuant to the Rome Statute? That has Article 27 in it.
Yes, and our submission would be Article 27 clearly says that when an individual appears before you, they cannot invoke an immunity. And we would say that that is the case. They cannot invoke an immunity if they're standing here in the courtroom before you. Article 27 applies to that individual. It's not applying to the state of Sudan, if you will. But then it's a different question if that individual is standing in Amman and you're asking the government of Jordan to arrest that individual. Now we're in Part 9 of the statute, which fully applies. Now we're in Article 98, where the court's not supposed to proceed with a request unless if there's a conflict between Jordan's obligations to another state.
But then, of course, Amman authorities would say to that individual, sir, we look at this thing. If you appear before this court, you will not enjoy immunity. Can you explain to us, please, on what basis we are to grant you immunity from a process that sent you to that court to be tried where you don't enjoy immunity? How do we resolve that?
Well, I think that the government of Sudan or that individual would say, Jordan, you have a treaty obligation under the Pact of the Arab League. You also have a treaty obligation under the 1953 Convention. I'm here at a summit. I'm protected by these. You're not allowed to arrest me. We are both parties to this treaty, my state and your state. Moreover, I submit that under customary international law, I believe I'm entitled to immunity. Jordan can't turn around and say, but I have a treaty obligation over here to which you're not a party, and that allows me to supersede my obligations to you. And if it did try to take that claim, presumably Sudan will say, well, wait a minute, as I look at your treaty obligation under the Rome Statute, there's an Article 98 that directly speaks to this. And it says when there's a conflicting obligation, the court shouldn't proceed unless you get my waiver. And I haven't waived.
I don't want to take us back to Security Council resolution about what it does, but you get the point. But please proceed.
Well, yeah, I mean, I think it's critical to the analysis, at least as the pretrial chamber advanced it, that even if Article 27 has an effect on Article 98, it's only vis-a-vis states parties. That's their theory. Non-state parties still can take advantage of the existence of the immunities. And so it's critical to have the Security Council resolution transform Sudan into being a quasi-state party, and that's what we're submitting is highly doubtful, including this idea that the entirety of the statute or some significant part of the statute applies to Sudan. If I can just pass to paragraph 2 of the resolution briefly to say a few words about the effect of paragraph 2. Paragraph 2 says, the prosecution says that the effect of the Council's referral and Sudan's obligation to cooperate fully with the court is that for the limited purpose of this situation, Sudan is placed into a situation comparable to that of a state party. So that's the theory. You put the two together somehow, and Sudan becomes a state party. In our view, the obligation to cooperate fully under paragraph 2 may well be interpreted as imposing an obligation on Sudan to surrender a person to this court when requested by the court. Paragraph 2 is clearly directed at Sudan and is clearly calling for cooperation with this court. But to us, it's a leap from that proposition to a claim that the resolution, even if you're then reading it in conjunction with Part 9 of the statute, obligates Sudan to waive the immunity of its head of state from the criminal jurisdiction of another state. That's a further proposition that we have doubts about. And most importantly for this proceeding, the resolution cannot possibly be viewed as requiring Jordan to disregard an immunity that it is obliged to give to Sudan. That clearly is not a part of paragraph 2 of the resolution. Now, the prosecution seeks to invent additional obligations in Part 9 based solely on this combined effects of paragraphs 1 and 2 of the Council's resolution. But if one could add obligations to Part 9 of the statute simply because certain actions, like a waiver of immunity, may be regarded as relating to the exercise of the jurisdiction of the court, then the list of potential obligations you could ram into Part 9 is endless. Merely the fact that the court's jurisdiction was triggered in Article 13b does not have the collateral effect of slicing down and diminishing and taking away the various provisions carefully negotiated that comprise Part 9 of the statute. And as Jordan explained in its appeals brief, even if Sudan has violated Resolution 1593, we believe that it's not open to Jordan, and certainly that Jordan is not under an obligation to remedy that situation. If there's a violation of the Council's resolution, that's between Sudan and the Security Council. So in sum, Jordan maintains its position that Security Council Resolution 1593 did not affect Jordan's obligations under customary and conventional international law to accord immunity to President al-Bashir. A referral of a situation does not turn a non-party state into a state party or place it in the status of being analogous to a party. And consequently, the pretrial chamber's legal reasoning basically falls apart, and our second ground of appeal should be upheld. That concludes my statement, Mr. President. Mr. Wood was going to continue to address the Group B questions, unless you have any questions for me at this time.
Thank you very much.
Mr. President, members of the Appeals Chamber, I shall endeavour to respond to at least some of the very interesting questions in Group B. I shall try to be brief, though I think each of them would deserve an article. A convenient way to address many of the questions would be to take you through the text of Security Council Resolution 1593 in a bit more detail, and explain what it does and what it does not do. And so if I could ask you to turn to the resolution, which is at page 4 in the folders. Mr. President, the resolution was adopted on the 31st of March 2005, following intense and difficult negotiations. This can be seen from the statements made after the vote, which are reproduced verbatim in the meeting record. The resolution was adopted by 11 votes in favour, with 4 abstentions. The abstentions were Algeria, Brazil, China, and the United States. And of course, as we all know, it was the first time that the Security Council had referred a situation to the prosecutor in accordance with Article 13b. The first preambular paragraph notes the report of the Commission of Inquiry, which you, Mr. President, described at the opening of this week, of this hearing. While that report is part of the background to the resolution, and while Council members were clearly well aware of it, it cannot, with respect, be invoked to read into the resolution, which, as I have said, was the result of lengthy negotiations, provisions which do not appear in the text. In particular, it cannot be read as supporting an implicit Council decision to strip high officials of Sudan of immunities that they enjoy in foreign states. The fourth preambular paragraph is of some interest, since in it the Council took note of the existence of agreements referred to in Article 98.2 of the statute. That is a reference, of course, not to sofas, but to the rather controversial Article 98 agreements that were being negotiated at the time by a non-party with many states. But it does show that the argument that Article 98.2 only covers sofas has no basis in the text or in practice. Next, and also in the preamble, we find a determination of a threat to international peace and security, followed by the statement that the Council is acting under Chapter 7. That, of course, is standard language when the Council is acting under Chapter 7, which it does particularly when it is adopting legally binding decisions. But it's important to recall that often, as was the case here, Chapter 7 resolutions contain a mixture of binding and non-binding provisions. This may be a good moment to respond to question E. That question concerns the significance, if any, of the fact that the Security Council referrals of situations to the court under Article 13b can only be made by the Security Council under Chapter 7, not under any other chapter of the UN Charter, nor by the UN General Assembly. It would not appear to me that this has any particular legal significance relevant to the present case. Article 13b seems to have been drafted carefully, having regard to the respective powers of the Security Council and the General Assembly. As I have already said, when the Security Council intends to take decisions with legal effect, as opposed to making recommendations, it normally acts under Chapter 7. Since referrals have legal effect, it is natural that the statute provides for them to be made by the Security Council acting under Chapter 7. Action by the Security Council under other provisions of the Charter and action by the General Assembly is not normally legally binding. Before turning to the operative paragraphs of the resolution, I should say a word about questions A and B, which concern the powers of the Council under Chapter 7. Question A asks a rather abstract question, whether under Chapter 7 the Security Council has the power to waive, displace or override the immunity of a head of state under customary international law or conventional international law. And if so, whether this must be done expressly or can it be done by necessary implication. It should first be noted that question A concerns an issue which in our submission is not on appeal. The theory of implicit waiver of immunity by virtue of Resolution 1593 was set aside by Pre-Trial Chamber 2 in the South Africa decision and in the decision now under appeal. But since the matter has been much discussed in the written pleadings in this appeal, I'll seek to answer question A without prejudice to our view that it's not relevant to the matters on appeal? And the answer, I believe, is as follows. It would indeed be open to the Security Council, in the exercise of its Chapter 7 powers, to decide with binding effect for UN member states to lift the immunity of a head of state under customary or conventional international law. But, and this is the essential point, to do so the Council would have to use clear language. It would have to expressly state that it was deciding to lift the immunity of the head of state. It simply did not do so. As a general matter, when it exercises its powers under Chapter 7, the Council needs to be careful to expressly indicate the scope of its binding decisions. As we all know, such decisions can be of the most serious nature, for example, authorizing the use of force. To interpret a resolution as taking a legally binding decision merely by implication on a matter as significant as the lifting of the immunity of a sitting head of state would set a dangerous precedent.
May I come here, please? And you may know this and address it later, but I thought this might be an appropriate time to interject the question gently. Perhaps the worry about necessary implication might have arisen in the following circumstances. The Kisese report clearly implicated senior government officials of Sudan and also foreign troops in violations. The Security Council resolution, in adopting Resolution 1593, does a carve-out, and that carve-out is to specifically say jurisdiction is not extended to foreign government officials or troops, but remains silent in relation to senior government officials of Sudan. So it raises the question, in referring the case to an ICC, is the Security Council to be presumed to not know that there is an Article 27 in there, 27.2 in that statute, that suggests at least that senior government officials are not immune proceedings? Are they presumed to be ignorant of that feature of it in referring the case to the ICC, knowing the finger pointing done in the report to senior government officials and foreign troops, but only exonerating, or rather carving out the exemption for foreign troops? That is what worries,
Yes.
perhaps puts in the picture the interpretation by necessary implication, and also another feature of it, just to develop the picture in the fullest form possible. In the course of advisory opinion, as well as the very helpful article you wrote in '95, to look at looking at statements made at the time, one sees that at the time of adoption of 1593, the president of the council at the time was Brazil. They abstained and made a very clear statement, reasons for their abstention. They said, we're abstaining because there is a carve-out. We do not want to sign on to this thing that exempts somebody from jurisdiction. And a lot of states who spoke on that also expressed disquiet about the carve-out, saying under the Rome Statute there should be no carve-out. When you send people there, they should be tried under the Rome Statute. We don't feel comfortable with this carve-out done in
Well, thank you
paragraph
very
6. This is what
yeah.
raises this question about necessary implication.
No, well, thank you very much. That's a very helpful explanation of the question. Firstly, I'm sure the members of the Council were fully cognizant of the text of the Rome Statute, and obviously they would have known about Article 27, but as we've explained, Article 27 relates not to immunity before domestic courts in the case of surrender, but it refers to immunity when someone is before this court. That is our position anyway. But as regards paragraph 6 of the resolution, which is the one you referred to with, as you called it, a carve-out, as I think we all know and is clear from the record, this was a very controversial paragraph. It was inserted into the resolution to avoid a veto by a permanent member of the Security Council. It's a very special provision, part of a negotiated package, to ensure that persons from a non-party contributing state are subject to the exclusive jurisdiction of that state and not within the jurisdiction of this court, unless the non-party's exclusive jurisdiction has been, and it says expressly, waived. So paragraph 6 concerns jurisdiction, which is not at issue in our case. It does not concern immunity, and in our submission it carries no implication that immunities under general international law do not apply. But it does show two things, I think. Firstly, paragraph 6 shows that the Council knew perfectly well, when it adopted the resolution, how to refer in its resolutions to a waiver, although in this case it was exclusive jurisdiction that was being waived, and it did so expressly. There was no, it didn't leave things to necessary implication. It referred to an express waiver of jurisdiction. So, turning back to the thought that there might be a necessary implication, I mean, my first comment on that is that it's a very subjective notion, a necessary implication. Some of us may see a necessary implication, others may not, in particular situations. But in our view, it would be extraordinary to read a specific legal obligation into a text, the waiver of immunity or the lifting of immunity, and perhaps especially into a Security Council text if the only basis for doing so is necessary implication. But in any event, we would submit there is absolutely nothing in 1593 from which it follows of necessity that immunity is lifted. I hope I've been able to answer your question. Just to recall, on the subject of waiver of immunity, under general international law, waiver of immunity must always be express, and this is reflected in the major international conventions on the subject. For example, the Vienna Convention on Diplomatic Relations provides expressly waiver must always be express, and the UN Convention on the Jurisdictional Immunities of States provides only for express consent to the exercise of jurisdiction. That's Article 7. Mr. President, I'm aware that time is moving on, so I'll try not to speak too fast in the remaining few minutes. Question B asked whether, acting under Chapter 7, the Security Council has the power to make provisions of the Rome Statute applicable to states that are not parties to it, and if so, whether this must be done expressly or can be done by necessary implication. My answer is the following. The Security Council, acting under Chapter 7, may indeed impose upon UN member states obligations corresponding to those that they would have under the provisions of a particular treaty, if they were parties to the treaty. But, like any other obligations imposed by the Security Council, this would have to be done expressly. It could not be done by implication, and it would in fact be a highly exceptional state for the Security Council to take. In our view, this is a hypothetical question since Resolution 1593 did not say that Sudan was bound by the Rome Statute, as Mr. Murphy has explained. I'd like to turn quickly to question C, which asks about the reference in Article 13 to the exercise of jurisdiction being in accordance with the provisions of the statute. Those words appear in the chapeau of the article, and they thus apply equally to all exercises of jurisdiction under Article 13. I think these words are one answer to the question you were putting to Professor Murphy, because they expressly say that the Council, when it's exercising its jurisdiction, following the court, when it's exercising its jurisdiction, following a referral, does so in accordance with the provisions of the statute. That is, all the provisions of the statute. They include Article 98. Question D.
Council has 5 minutes left.
5 minutes. Thank you. In which case I'll be a little selective in my responses, but there'll be an opportunity perhaps later. I'll turn to the question about questions G and H. As they say, paragraph 2 imposes an obligation on Sudan to cooperate fully, whereas it only urges other states, such as Jordan, to do so. The Council did not impose a legal obligation on Jordan or other states. It's obviously, we would say, an important distinction. For the Security Council to urge states to cooperate does not authorize them to do that which would otherwise be unlawful, such as to ignore their obligations in relation to immunities. Under Article 103 of the Charter, it's only Charter obligations, which include obligations imposed by the Council, that prevail over any other obligations under international agreements, or, I would agree, under customary international law. The Council did not impose new obligations on states other than the Sudan, so the language of the resolution did not relieve Jordan or any other state of its obligations towards Sudan to respect the immunity of the President. I've dealt with paragraph 6. I'll turn lastly, if I may, to question L, which is, again, we say hypothetical, but it's a very interesting question. And it's would things have been different if the Security Council had established a Yugoslav or Rwanda-type ad hoc tribunal for the situation in Darfur? Well, obviously, the answer would depend on the precise terms of the resolution and the accompanying statute, but it's likely that the position would have been very different in two fundamental ways. Firstly, the resolution and statute would presumably have imposed obligations equally on all member states of the United Nations. There would not have been states parties and non-parties. And second, by virtue of Article 103 of the United Nations Charter, those obligations under the resolution and statute, being obligations under the Charter, would have prevailed over all other obligations that the member states might have. Question L goes on to ask whether, if a similar tribunal had been established for the situation in Darfur, the President of Sudan would have enjoyed immunity before the tribunal. I'm a bit reluctant to try and answer a hypothetical question. The answer would depend upon a correct interpretation of the Security Council resolution and statute, which, as we've explained, would require having regard to a whole range of elements, including the negotiating history, statements made in the Council in relation to that particular resolution, and the like. Mr. President, I think I've used up all my time, and I thank you very much.
Thank you very much. So, Michael, before you sit, maybe later again, you might want to ponder on this. In that article you wrote in 1995, you spoke to who interprets, who gives an authentic interpretation of Security Council, and you come to the conclusion, sensibly of course, that of course the author of it is the best person to tell us what they mean. But then you do suggest that there have been precedents in the past, or there may be circumstances in which the council comes in to correct an interpretation that might have been misdone in the past. And you give the example of a certain resolution in 1995, resolution
Bosnia.
1970 of 1995, 12 January 1995, where the council felt somewhat compelled to come and clarify what it meant by a previous resolution. Apparently, a certain legal officer had given an interpretation, and council came back and reasserted what it meant. You know what I'm talking about. It's in the paper at page 83, I think, of that article. The question becomes this. Here we are, so many years after passage of adoption of 1593. At least 5 instances of, or so at least that much of pre-trial chamber saying there is no immunity. Might one have expected the council to have intervened and said, hang on, you got it wrong. We did not say there is no immunity. Could we have expected that from the council to reverse the certain question that's been hanging around? You might want to think about it, and perhaps after you looked at that material I just referred to that you wrote, then
Yes.
address it, please.
Well, if I could just respond very quickly and then think about it. I speak first and then I think.
It helps lawyers
The,
sometimes.
the Security Council, of course, is a very political body, and one should not expect it to act consistently. Politics enter into everything it does. Sometimes it takes action, sometimes it doesn't take action. Sometimes it may clarify a resolution. It's pretty rare, I have to say, because if a dispute's arisen, it's likely to be one that also arises within the council. So all I was saying in that article was making the legal point that the authentic interpretation is by the body that issued the document. There's case law for that, though of course everyone can try and interpret it. And then I had to struggle to find examples where the council had actually interpreted its past resolutions, and I think I found a couple, but it's very rare. And you wouldn't expect, I would not expect the council routinely to be issuing interpretations of its resolution. On the other hand, having said that, and as we've already said, the subsequent practice within the council, what is said within the council, what happens when the prosecutor reports to the council, this can all be taken into account in interpreting the resolution. But that's quite different from your question, which was about the rather formal process of authentic interpretation.
But might the pressure, perhaps political pressure, generated by the request of the African Union for deferral of the case after the indictment of Sudan, might it have somehow raised an expectation that if the Security Council really wanted to intervene and perhaps diffuse the political tension, this is one way that it might have done it, to come in and say, well, yes, you may proceed against other government officials, but you need not proceed against the head of state on grounds of immunity.
Well, I wouldn't want to speculate about what happened on that particular occasion. We heard this morning, I think, that it was really with a view to improving a peace process or promoting a peace process rather than a particular concern about immunity that led to that request. I think the council is, as I said, a highly political body. You have to look very carefully at everything that was said, and you have to know the background for each case.
Thank you very much. So we are left on our own with just the point of it all. Thank you very much, Mr. Wood. Now we will take submissions from the prosecutor.
Good afternoon, Your Honours. I'll now address your questions in Group B of the scheduling order relating to the effects of the Security Council referrals under Article 13B of the Rome Statute, the powers of the Security Council under Chapter 7 of the UN Charter, and the proper interpretation of Resolution 1593. My answers are intended to provide further support for our position. It's already been fully briefed that the pretrial chamber majority in the Jordan decision correctly understood the effect of the Security Council referral by Resolution 1593 for Sudan and consequently for Jordan when requested by the court to arrest and surrender Mr. al-Bashir. The net outcome of this being that Jordan was obliged to arrest and surrender Mr. al-Bashir, notwithstanding any immunity he may otherwise arguably have enjoyed under customary or conventional international law. Now, I think at this point it's helpful to briefly recall the majority's reasoning, which we say was correct. And in fact, in our view, it was clear, it was legally solid, and this is the reasoning that we encourage Your Honours to follow. The majority found that the Security Council's referral of the Darfur situation to the court had the following effects. 1, the legal framework of the Rome Statute applies to the referred situation. 2, Resolution 1593 obliges Sudan to fully cooperate with the court in accordance with the Rome Statute. And 3, this thereby places Sudan in an analogous position to a state party to the statute in terms of its rights and duties under the statute for the limited purpose of the situation. As such, Sudan was bound, therefore, by the cooperation obligations in the Rome Statute, that is, those in Part 9, as well as Article 27. And as we heard yesterday, my colleague Mr. Cross elaborated, that provision, Article 27, subparagraph 2, prevents any otherwise applicable immunities under international law being raised before the court, both by state parties in their vertical relations with the court and in their horizontal relations with each other. Although Sudan is not a state party to the statute, its obligation as a UN member state to accept decisions of the Security Council acting under Chapter 7 means not only that it must accept the ICC's jurisdiction, but also that it must comply with provisions that make that jurisdiction effective. That is, the cooperation provisions and Article 27(2). And then the logic of the majority, which we agree with, is that since Article 27, subparagraph 2, is deemed binding on Sudan, Sudan cannot claim any head of state immunity otherwise existing under international law, and accordingly Article 98(1) did not bar the court from proceeding with the request to Jordan to arrest and surrender Sudan's head of state. And thereby, Jordan was obliged to comply with its obligations under the statute, Articles 86 and 89, precisely because it did not owe a relevant international law obligation to Sudan concerning Mr. Bashir's immunity. And as I said, we say that reasoning is unassailable and should be upheld. So the first thing I want to talk about is the correctness of the pretrial chamber's reasoning about the effect of the Security Council referral. Because obviously a key issue in this appeal is whether the majority was correct about those findings on the effect of the referral. And in our view, it was. Resolution 1593, referring the situation under Article 13b of the statute, not only triggered the court's jurisdiction over Darfur's situation, it had these effects. It invoked the legal framework of the statute for the referred situation. It obliged Sudan to cooperate fully in accordance with the statute, and it placed Sudan in a comparable position to a state party in terms of its rights and duties. So in this respect, we disagree with Jordan's submissions that the referral by the Security Council merely triggers the jurisdiction. It has these broader effects, as the pretrial chamber had found. And nor would these need to be expressly provided for, as they also argued, because in our view it's the necessary effect of a referral under Article 13b. And I'll show you why that interpretation is correct in a moment. But at this point, I'll just backtrack, I guess, and I'll answer your questions on the powers of the Security Council under Chapter 7 of the UN Charter. This is questions A and B, because that's a very important lens from which you need to understand that one understands the effect of the referral. Now, it's trite to say that under Chapter 7 of the UN Charter, the Security Council has broad powers to take measures once it identifies a threat to international peace and security, indeed up to and including the use of force. The limits on those powers are that such measures cannot violate use cogens norms, nor can they violate the purposes and principles of the UN. And such Chapter 7 decisions by the Security Council are fully binding on UN member states under Article 25 of the Charter. I don't think there's any contention with what I've said so far. To answer Your Honour's, Your Honour Judge Ebo Asuji yesterday asked a question about whether those powers may override both conventional law and customary international law pursuant to Article 103. Your Honours, we say it can, and that's a conclusion which was also reached by the ILC in its fragmentation study. I refer Your Honours to the authorities that we have on that in our list of authorities, B1. And as well, Judge Perrin de Brichambeau recognised in his separate opinion in the South Africa decision, he noted that there are these different academic positions on this question, but he also came to the same conclusion. So again, that much seems established. If I could call it the classic rule, is that a treaty such as the Rome Statute does not itself impose obligations upon a state not party to it. This is a rule of customary international law. It's codified in the Vienna Convention, Article 34. It's not a use cogens norm. That as well, it goes without saying. So under Chapter 7, if deemed necessary to restore international peace and security, that's the trigger for the Security Council's powers under Chapter 7, the Security Council is empowered to make a UN member state bound by whatever obligations the Council deems appropriate, including those set out in a multilateral treaty to which the state is not otherwise bound. So the short answer to question B, Your Honours, you've asked, does the Security Council have the power to make conventional provisions of the statute applicable to states not party to it, is yes. And in this respect, we're talking about the obligations in the treaty, of course, the obligations in the Rome Statute. Your question goes on to ask, must this be done expressly? In our view, no, so long as it was the necessary and unseverable effect. In other words, another way of putting it, it's the necessary implication of the Security Council's decision. as it was here through the referral under Article 13b. Indeed, this is exactly what the Security Council did here by referring the situation in Darfur. It's exactly what is foreseen by Article 13b. The obligations in the statute become incumbent on the relevant state. So although Sudan has not ratified the statute, it's a non-state party, it has ratified the UN Charter, and it's thereby consented to the Security Council's powers in Chapter 7 to take necessary measures to maintain international peace and security, including, if the Council so chooses, by referring a situation to the court and thereby imposing the obligations in the statute on a non-state party. I'll come back to this point at a later point in my submissions, but for the same reason, and directly answering question A, Your Honours, the Security Council has the power under Chapter 7 to, quote, waive, displace or override, end of quote, that's from your question, the immunity of a head of state under customary or conventional law to the extent they may otherwise be applicable. It's our position that this would not override a jus cogens norm, immunity is not a jus cogens norm, nor, to the extent that you might want to accommodate this concern, nor would it violate a fundamental human right. And I think whether we call it, we've had a debate yesterday and today, whether we call this a privilege or a right, that's really just a terminology question. What is clear is that it's not a fundamental human right of the person, because we know, and Professor Latanzi underscored this point yesterday, that such an immunity belongs to the state and can be waived by it. And in our view, this a waiver, or displacement rather, of immunity would not need to be spelled out by express words in the resolution when it's already the necessary effect. In other words, the clear implication of the Security Council's decision to refer. And I will get back to that point in a moment. But at this point, Your Honours, I want to make a very brief word about question J. You've asked whether a UN member state can plead its own sovereign immunity to avoid the effects of a Chapter 7 measure. Mr. Raston mentioned yesterday, head of state immunity does derive essentially from the notion of state sovereignty. Mr. O'Keefe made further submissions about that being the need to ensure non-interference in the functioning and sovereignty of one state by another, the ability to conduct international relations freely. That's all true. And it's also true that the UN was designed as a collective way that states would try and accomplish the aims such as the maintenance of peace and security. But this doesn't mean that a state should be entitled to plead its own sovereign immunity to avoid the effects of a Chapter 7 measure. In fact, Your Honours, and I point you to the authorities that we've filed, you will know this very well, this line of cases, a similar claim was rejected in the Blaskich case by the ICTY Trial and Appeals Chamber, which is referenced at B2. We also make the comment that if we were to say otherwise, that they could put up their own sovereign immunity, it would defeat the point of states having agreed to give the Security Council its broad and binding Chapter 7 powers. It could well defeat the purpose of such measures. If you think about it, such an argument would a fortiori preclude the Security Council's authorization of use of force against a sovereign state. And that's something expressly contemplated under the Charter, Article 43. Just to complete this set of questions on powers of the Security Council, because I'm trying to group them all before turning to show you the necessary effect of the article. In a similar vein, in question K, you've asked can a state plead a rule of customary international law as a bar against implementing a decision taken by the Security Council under Chapter 7? Well, it can't, and that's with particular, that we just have to look at Article 25 and 103 of the UN Charter. And again, so long as it's not a jus cogens norm, and head of state immunity clearly is not. Your Honours, now I think this is the most important part of our submission relating to ground 2 and the Security Council route taken by the pre-trial chamber. And this is the necessary effect of a referral under Article 13b. In question C, you've asked, what was the intendment of that article? We've set out in many pages of our response brief and various other filings how if you take a correct Vienna Convention interpretation of that provision, ordinary meaning, read in context, in light of object and purpose, it confirms that the majority did indeed correctly understand the effect of the Security Council referral. Now, Your Honours will see on Evidence Channel 2, you know it probably by heart by now, but this is the provision, Article 13b. I want to look first at the ordinary terms of Article 13b, and in particular, the chapeau of that article. And it applies to all three trigger mechanisms, and it provides the court may exercise its jurisdiction with respect to a crime in Article 5 in accordance with the provisions of this statute. And I underscore those words. It's been argued by Jordan. We've seen it in the filings of some of the other professors or the African Union or the League of Arab States that this has to be read very narrowly as just meaning the court's jurisdiction in the narrow sense, but not all of those provisions necessary to make the jurisdiction effective, in particular the obligations of Part 9 and the limitation of immunities in Article 27. We think this is a very constrained and excessively narrow reading of these clear terms. And we can get even more assistance, as it were, from the interpretation if we read these terms in context with other relevant provisions which support that interpretation. And the interpretation leads to the conclusion that no matter how jurisdiction is triggered, there's one regime applicable at the court, the Rome Statute regime. In this regard, Your Honours, I point you to Article 1 of the statute, which provides that the jurisdiction and functioning of the court shall be governed by the provisions of this statute. Also, as my colleague Mr. Cross mentioned, Article 21, 1A on applicable law. Something that hasn't been mentioned yet, is very important to this analysis, is Article 17.1 of the UN ICC Relationship Agreement. It expressly states that a referral of a situation by the Security Council to the court will occur, quote, pursuant to Article 13b of the statute. This is further proof that Article 13b forms part of the critical legal architecture that binds the relationship between the ICC and the UN and indeed the Security Council in relevant part.
It's then not in your, as I understand it, it's not a question of, res inter alios acta. In thing, the treaty only operating amongst those who've consented to it, but it's basically something else, more forceful than that reaches beyond just the parties to the treaty.
Absolutely, Your Honour. Yeah. Absolutely. Because when you come to 13b, this court's jurisdiction obviously has a much broader effect. It has a potential for worldwide jurisdiction, unlike if there's a state party referral or a proprio moto, where it is just restricted to state parties. That's key in our opinion. The interpretation that I've advocated and that the pre-trial chamber majority adopted also serves the object and purpose of Article 13 and the statute more generally. So by making the whole legal framework of the statute applicable to the referred situation and imposing these analogous duties like a state party, it renders referrals effective. It also promotes consistency and coherence, because no matter how the court's jurisdiction is triggered, and indeed even if it's by way of an Article 12.3 declaration, the same regime applies, the Rome Statute one. So it's no surprise from everything I've said that it follows, and answering question D, that yes, the pre-trial chamber majority was correct that Article 13b does entail the application of the statute to a non-state party on the same basis as a state party. And here's a caveat in some respects, and also addressing Your Honour's question just asked of my colleague, Mr. Murphy, at least to the extent necessary to ensure that the referral and the court's exercise of jurisdiction is effective. Mr. Murphy asked, well, which ones? We don't know, unclear as to which provisions of the statute. What we say is it means the jurisdictional and the cooperation obligations, and not, for example, the governance provisions, the right to vote in the ASP, the duty to pay contributions. Your Honours, the pre-trial chamber expressed this very well in its South Africa decision at paragraph 88, when they said, the source of the duty to cooperate for the non-state party, here Sudan, is Resolution 1593, but the content of the duty is set by the statute. Now, we turn to a very important aspect, and that is the drafting history of Article 13b. In our view, this interpretation of Article 13b is supported by the statute's drafting history. And just briefly dealing with question E, it is significant that the final outcome chosen for this article was that the referrals could only be accomplished by the Security Council acting under Chapter 7, as opposed, for example, to another chapter or by the General Assembly. Because, of course, as Mr. Wood has already said, only the Security Council has, using its Chapter 7 powers, the authority to make decisions which have binding effect on all member states, unlike a recommendation by, for example, the General Assembly. So let's have a look at just some aspects. It's a long process, obviously, in the drafting and negotiation, but starting first at the first draft for the ICC, the ILC draft statute, the 1994. Already we can see, or in the ILC chose to include draft Article 23.1, which contemplated that giving the court jurisdiction over crimes if the Security Council referred a matter. At that point actually it was called a matter, not a situation. It morphed, but referring a matter to the court under Chapter 7. And it's important to, I think, have a look at the commentary in paragraph 1, because the ILC noted specifically that this was not a separate strand of jurisdiction for the court, but rather an avenue of recourse for the court by dispensing with the otherwise applicable state consent requirements in Article 21. And it specifically noted, quote, I'm quoting now, the provision is necessary to enable the council to make use of the court rather than establishing ad hoc tribunals as a response to crimes which affront the conscience of humankind. And indeed, the ILC members had actually discussed whether the General Assembly also ought to be able to refer matters where the Security Council was hampered by a veto. But they rejected it, and I think it's very telling in why they rejected it. in paragraph 5 of the commentary, they said, the General Assembly lacked authority under the Charter to directly affect the rights of states against their will, especially in respect of issues of criminal jurisdiction. And we see similar views echoed in the report of the Ad Hoc Committee, September of 1995. Again, in paragraph 120 of the report, several delegations, it's reported there that several delegations believed that, consistent with the Security Council's role, a primary responsibility to maintain peace and security and its powers, the Security Council should be authorised to, quote, refer matters to the court to obviate the need to create ad hoc tribunals and enhance the effectiveness of the court as a consequence of Chapter 7 referrals, end of quote. And Your Honours, I also point you to the chapters by Elizabeth Wilmshurst and Lionel Yee referenced in B3, because we see this motive for creating the UN Security Council mechanism, the referral mechanism, had then manifested itself by being included. Now, that's not to say there were not. I think Mr. Jallo this morning said that there were opponents, and there were. And some of those opponents hung on until the very last moment. But it was finally included. What can we draw from this negotiation and drafting history? In our view, two key points. Firstly, the drafters saw the Article 13b referral route as a more efficient and economical substitute for creating a new ad hoc tribunal every time.
A very cheap one, isn't it?
That's key.
A very cheap one. The one you don't have to pay
Oh,
for.
well, we could, perhaps ask for some more money, that's for sure. Secondly, drafters saw the need for referrals to have a binding effect on member states, including non-state parties. So both these points say much about what the drafters intended to be the effect of such a referral for states not party to the statute. At this stage, it's a good point for me to address question L, which asks whether there's a difference between the Security Council using its Chapter 7 powers to refer a situation to the ICC and using those powers to create a new ad hoc tribunal, a la the ICTY or ICTR. In our view, in terms of legal effect, and here I'm talking about the state concerned, I'll come to another point about the effect for other states, but insofar as the state concerned, there's no palpable difference. Now, having said that, I'm not downplaying that there are obvious differences between the ICC and the ad hocs in terms of their scope of jurisdiction, their functioning, and their structure. The ad hoc tribunals were created and existed as subsidiary bodies of the Security Council within the UN system and had primacy of jurisdiction over national courts, and all member states, all UN member states, were obliged to comply with their orders. On the other hand, the ICC, while conceived within the UN auspices, to use your terms in question F, the brainchild of the UN, it ultimately was established by way of a multilateral treaty, being the Rome Statute, as a separate entity existing outside the UN system, but with a defined relationship with it. And it's got a complementary jurisdiction to national courts. So if you just look at the situation without or absent a Security Council referral, the ICC operates on a state consent model based on ratification of the statute. That means that for the state party referrals and proprio moto situations, the court can only exercise jurisdiction when crimes occurred on the territory or by a national of a state party. And for those tracks, its orders can only bind state parties, but not non-state parties, But these differences, in our view, fall away when the Security Council refers a situation under Article 13b and thereby engages a potentially worldwide reach of jurisdiction. If there's a referral by the Security Council, the ICC can exercise jurisdiction over crimes when committed in the territory or by a national of a non-state party. And that state then becomes obliged to cooperate. And then, and it will, depending on how the resolution is expressed, and I'll get to the expression in Resolution 1593 in a moment, but depending on that expression, other UN member states, whether they have ratified or not, can also be obliged to comply or otherwise urged to do so. Another point that I will also develop further, but just to complete the answer on question L, because it has a second aspect, if instead of referring to the ICC, the Darfur situation, the Security Council had created a new ad hoc tribunal for Darfur, and let's assume it was modelled on the exact same template of the resolutions for the ICTY and ICTR, and let's assume that it was the exact same statutes that applied. Sudan, speaking of Sudan, would have been obliged to comply with the terms of the statute and the resolution, and could not have raised Mr. Bashir's head of state immunity to bar his arrest and surrender to the court. And neither could other states have done so. Now, having said that, I note, I have to concede, that the point was never tested in court because, as we've heard, by the time former President Milosevic was transferred to the ICTY, he was no longer president. But, Your Honours, it seems absurd to suggest that the ICC, which was referred a situation by the Security Council, should have less powers than a Security Council-created body when the referral was made to avert the need to create another ad hoc tribunal. So that's putting, what I've done so far is to put how Article 13b referrals work, what's the effect of them, because that's very important for when we come to interpret Resolution 1593. And at this point, I'd like to take a closer look at that resolution, and in doing so, I plan to address questions G, H, and I on some specific items you've pointed us to. But I thought it would be helpful at this point to remind you of my answer on question A about the Security Council's power to remove or displace immunities. As I've already said, given the Security Council's broad powers under Chapter 7, the Security Council has the power to remove the immunity of a head of state otherwise existent under custom or conventional law. And I think this much is accepted and recognised by Jordan and the AU. We're talking about powers here, the other Professor O'Keefe and others. But their argument is that to remove such immunity would be so significant, it would have to be done explicitly and not merely by necessary implication. And then they say express language in the resolution would be needed to override such a fundamental rule of international law. In our view, Your Honours, such express terms are not required when it's the necessary effect or the necessary implication of the referral. When the Security Council adopted 1593, the necessary effect of the referral was that the statute, including Article 27(2), would apply, thus rendering inapplicable head of state immunity. And the majority put it like this, I thought very well. They said this was the necessary and unseverable effect of the Security Council's informed choice, harping back to a point that Your Honour had made to one of the questions, informed choice to trigger jurisdiction and impose on Sudan the obligation to cooperate with it. That's at paragraph 40. So for that reason, the majority didn't actually rely on the theory that Resolution 1593 impliedly waived Mr. Bashir's immunity. They didn't need to, because they had already found that it was the necessary effect. But in our view, a proper, taking all that and agreeing with it, in our view, a proper interpretation of the resolution does lead to that conclusion. Now, we agree with Mr. Murphy when he made the point that a Security Council resolution may call for a broader consideration of factors other than those in the Vienna Convention. Mr. Wood
Is there a difficulty there with could it be the reason why the terminology of waiver raises the red flag is because of a certain understanding of it, that you cannot waive what doesn't belong to you?
Quite possibly.
Is there something in there?
Quite possibly. I think this word waiver we might be getting stuck on because, in fact, and following the pretrial chamber's reasoning, it was the necessary effect of referral. So the chamber didn't need to go looking for specific words of express waiver. It was the effect of the referral itself. But our point is that, well, actually, if you look at the whole resolution and you apply the proper Vienna Convention approach, you would come to the conclusion, and if I could take that the immunities were disapplied, you will come to the same position.
Basically, the point being negation of right or privilege, however that is achieved.
Exactly, Your Honour, exactly. So I was very guided by Mr. Wood's insightful articles written about the topic of interpreting Security Council resolutions. We have them in B4 of our reference list. And for this reason in particular, I think that the proper lens upon which to start the interpretation of the resolution is to look at the background to its adoption. Your Honour, yesterday in the introduction you spoke at some length about the Commission of Inquiry report. And as you noted, that Cassese Commission of Inquiry had been commissioned by the Security Council under Resolution 1564 specifically to investigate reports of violations of IHL and human rights in Darfur, to determine whether acts of genocide had occurred, and to identify the perpetrators, to ensure that those who, with a view to ensuring that those responsible are held accountable. And that's exactly what this commission did. Your Honour summarised those findings, so I don't need to redo it, and don't have time to redo it. But the most important findings from the commission are very serious international crimes, crimes against humanity, war crimes, acts of genocide. Yes, we take the point that at that point the commission did not find a policy of genocide, but they did find that acts of genocide had occurred. Then, if you look at who are the perpetrators identified included senior officials of the government of Sudan. And those words, officials of government of Sudan or senior officials, are peppered throughout the Commission of Inquiry. And then, of course, they recommended immediate referral to the ICC. So that's the first, we think, very important background piece of information to have in mind. The second is that, of course, by the time that Resolution 1593 was adopted in March of 2005, the court was already fully functional. It had its established applicable law. The UN-ICC relationship agreement had been adopted by that stage. The relevant instruments were therefore already in existence and could have occasioned no doubt. So no further express reference was needed. Another point that is important to take into account is that it's revealing that the Security Council had already used the language of, quote, shall cooperate fully in its earlier resolutions 827 and 955 in the 1990s when establishing the ad hoc tribunals. And neither of those, if you look at the resolution, neither of these had expressly waived immunities. And yet, and then we fast forward ourselves to 2005, March of 2005, when the Security Council is considering and adopting this resolution, it was widely accepted that this formula removed head of state immunities. And I draw on a comment made yesterday by my learned colleague, Mr. Kress. He mentioned it in a different context in the establishment of customary international law, but I want to say it in terms of what was in the mind of the Security Council. By then, states seem to have generally accepted the ICTY's 1999 indictment against then-sitting President Milosevic. Although, again, I know and I concede that the point was ultimately never tested at the ICTY because when he was transferred, he was no longer president. But in our view, it's irrelevant that in the ad hoc resolutions, the Security Council both created the tribunals and annexed the statutes, because the same modus is used. For all three of them, the Security Council, acting under Chapter 7, ordered the relevant state, former Yugoslavia or Sudan, to cooperate fully with an instrument that removed immunities, ICC through Article 27, and the ad hocs through their respective Articles 7.2 and 6.3. Just finally on this point of what was in the back of their mind, if we could put it like that, is that by 2005, the appeals chamber of the Sierra Leone court had already rendered its 2004 decision in which it had overruled Charles Taylor's claim that the arrest warrant against him was invalid on the basis that when the 2003 indictment was issued against him, he was the sitting head of state of Liberia. Your Honours, this background informs us when we seek to interpret the terms of Resolution 1593 and parts of it.
It is one thing to say that the Security Council is presumed to know the terms of Article 27. It's part of the Rome Statute they were referred to. Can we also say that about the judgment of the Appeals Chamber of the Special Court for Sierra Leone?
I think, well, it was something that was very well publicised. I mean, I know that this is sort of my area, but I would say that this was quite a worldwide known event because it was quite significant, both for Milosevic and for Charles Taylor.
The fact of the arrest, yes, but whether the Security Council would know that the appeals chamber of the SCSL had made that pronouncement.
Well, Your Honour, maybe that would be going too far to know the exact decision, but it was more, I was making the point that they would have known the outcome of the decision, not every last detail about the decision itself. So, Your Honours, coming to interpret the terms of Resolution 1593, we agree with Mr. Murphy that if you look at paragraph 2, in express terms, it's not about immunities. It's about cooperation obligations. There's no quibble with that point. It requires Sudan to cooperate fully, and then says, after recognising that states not party to the Rome Statute have no obligation under the statute, urges other states to do so. And in question G, you've asked about this legal significance of this distinction. Turning first to what shall cooperate fully means for Sudan, I don't think there's any dispute about this. With Jordan, it clearly obliged Sudan for the Darfur situation to cooperate with the court. But we also say, and this is where we have a dispute with Jordan and some of the others, we also say it meant that that as the pre-trial chamber majority found, subject to the same obligations and limitations as a state party, including those in Part 9, and not being able to raise head of state immunity to bar arrest and surrender. Then we turn to what does it mean urging other states to fully cooperate. Well, it's well known that non-state parties, apart from Sudan, are not obliged to comply with orders from the court, but are urged to do so. The Rome Statute and its obligations are not imposed on them, so they wouldn't be bound to comply with a court request to execute an arrest warrant for the situation, but they're only strongly encouraged to do so. For state parties, the situation's different. They have to comply by virtue of their obligations.
You are keeping an eye on the time. You've got about
10
5 minutes or
Yep, that's
so.
fine. All right. But, Your Honours, what if, this comes to the second part of question G, what if a non-state party chose to voluntarily comply with a court request to arrest and surrender Sudan's head of state? You've asked in question G whether the obligation on Sudan to cooperate fully has the same effect for states non-party from the perspective of Article 98. Your Honours, this is a difficult question to answer, and it actually goes beyond the facts of this case. However, it, in our view, would be open to argue that since Sudan is bound to accept the court's jurisdiction and to cooperate fully with it, and could not raise, by virtue of Article 27, his immunity, that any such immunity would likewise not be opposable in the case that a non-state party voluntarily decided to cooperate and arrest him. But I think we don't actually have to answer that question because it doesn't arise in these facts. Your Honours, I'll turn quickly to look at some other paragraphs in the resolution which also suggest that the Security Council did intend to waive official capacity immunity, or that rather that official capacity immunities should not apply vis-a-vis Sudan. The preamble's first paragraph, which refers to the Commission's report on Darfur, the report that, as Your Honour mentioned yesterday, detailed a catalogue of Sudanese government-orchestrated violence, the potential involvement of senior Sudanese government officials, and recommended referral. You've also noted in your questions paragraph 6 of the resolution and asked about the significance of paragraph 6 when we read the resolution. Your Honours, paragraph 6 shows that the Security Council was aware of potential specific exceptions to the court's jurisdiction and sought to provide for it where it saw fit. The fact that it said nothing about head of state immunities for high-level Sudanese government or state officials, despite knowing of their possible involvement in the Darfur crimes through the Commission of Inquiry report, implies the opposite, in our view. Had the Security Council meant to exempt another category from the court's jurisdiction, one would expect the Council to have said something. Your Honours, the non-applicability of immunities also accords with the object and purpose of the resolution. Obviously, the main purpose is to refer the situation in Darfur to the court, but without the removal of immunities for Sudanese state officials, the referral would be largely, if not wholly, ineffective. And this brings me to question N of your questions, where you ask whether recognising his immunity would render Resolution 1593 wholly or substantially ineffective. And we say it would, at least substantially. It's true that Mr. Bashir's personal immunity as head of state will only last as long as he's in power, and it's true that the investigations go beyond him. He's just one person. But again, we have to recall that the Commission of Inquiry had reported to the Security Council a pattern of government-orchestrated violence involving the entire security and defence apparatus of the state in coordinated military campaigns. If the President of Sudan, the person alleged to be at the top level of this machinery, remains immune even for this period, it would greatly undermine the scope of the court's inquiry as well as the deterrent and preventative effect of the resolution and referral. Not to mention, greatly hamper the court's ability to effectively pursue cases and warrants against other persons apart from him. And as Your Honour correctly noted, with the passage of more time, it becomes more and more difficult in terms of collection of evidence, preservation of evidence for trials and prosecutions. I won't say much on the subsequent practice. We know that it's unclear for insight, but I think the two main things that are very important to draw from subsequent practice, in particular from the Security Council angle, is this point that although the African Union has requested twice has requested the Security Council to defer proceedings against Mr. Bashir twice under Article 16, it's declined to do so. And I think although it wasn't expressly written in the Article 16 request, it's clear from all the other statements that the AU has made, they're cited by Judge Brishambault in his separate opinion, that that was the reason motivating the AU to do so. Another thing, another illustrative tool when looking at this resolution is to note that when the Security Council adopted Resolution 1970, referring Libya situation to the court, it used the same language. Again, another indication that the Security Council did not think that the court had gone beyond the scope of the referral in Resolution 1593. I may be soon out of time. I'm out of time.
I'm sorry, your time
I was
is
out
up.
of time. All right. Well, I will not say. The only question I think I haven't answered in this group is question M, but I'm happy to take questions on that. Thank you.
Thank you very much. We will leave it there for the day, and we will resume tomorrow, and we will start at 9:30 tomorrow. We'll rise now.
All rise.